Hi, I'm firearms attorney Gilbert Ambler, and today we're going to be talking about another decision from the Fifth Circuit, this time from the Northern District of Texas, Judge O'Connor, who's issued a decision that this time is helpful to owners of forced reset triggers. And of course, Judge O'Connor responsible for a couple of other decisions, the framer-receiver rule, responsible for the most recent injunction against the pistol brace ban. So a couple of good decisions from Judge O'Connor. This one about forced reset triggers. Now previously, Judge O'Connor had issued a temporary restraining order, a TRO, on forced reset triggers, preventing the ATF from prosecuting somebody for possession of an unlawful machine gun because they possessed a forced reset trigger. But that TRO applied only to the named plaintiffs in a lawsuit. This time, the preliminary injunction that has been issued applies to the organization and the members of the organization of National Association for Gun Rights and Texas Gun Rights. So all of a sudden, this injunction is expanded to cover the members of these organizations, which means if you are a member of National Association for Gun Rights and you have a forced reset trigger, Judge O'Connor has just stopped the ATF from enforcing the prohibition of possession of a forced reset trigger against you, which is huge. However, before we dive into this subject a little bit further, if you have not yet hit that subscribe button, go ahead, hit subscribe for us. Like, comment with your thoughts, share with your friends. That way you and your friends can keep getting this important Second Amendment related content. All right, quick refresher on forced reset triggers. A forced reset trigger, similar to a bump stock, speeds up the way that a traditional firearm is able to fire through allowing the shooter to depress the trigger much more rapidly. Essentially, it is forward pressure on the trigger that allows the trigger to reset much more rapidly than a stock trigger. The rearward pressure from the shooter's finger allows the firearm to discharge more rapidly. Critically, a forced reset trigger does not discharge multiple rounds through a single pull of the trigger, but rather facilitates the trigger being pulled much more rapidly. And that's a critical distinction when we talk about what counts as a machine gun and what is not a machine gun. Of course, back in 2021, the ATF started to take the position that forced reset triggers were in fact machine guns and as such were unlawful. Pursuant to the Hughes Amendment, of course, you can't make new machine guns, and these are all being made in 2021, 2022, 2023, the ones that are being targeted. So if in fact they discharge more than one round per pull of the trigger, then we've got a serious problem under federal law. Now, the interesting thing is for National Association of Gun Rights, it was a no-brainer to sue in the Fifth Circuit because the Fifth Circuit has already been helpful on bump stocks in the Cargill case. And if the Fifth Circuit is looking at bump stocks and saying, yes, they speed up the rate of fire, but no, it does not result in more than one round being discharged per pull of the trigger, and therefore it is not a machine gun per the definition of a machine gun, then it was very likely that the Fifth Circuit was going to be helpful on forced reset triggers as well. Now, this is very, very helpful for anybody who happens to possess a forced reset trigger, because those folks that went out and bought forced reset triggers at the time they were purchasing them didn't think that there was anything wrong with what they were buying. In fact, they thought they were buying a legal accessory. Got shipped to their house, didn't seem to be anything wrong with it until the ATF started sending letters to folks. And when they started sending letters to folks, what they were saying was, you are in possession of an illegal machine gun. We suspect you of being in possession. They got shipping records from the various companies and started sending letters to people that had these triggers saying, you're in possession of an illegal machine gun. You should turn it in to us. And of course, that put folks in a very, very uncomfortable scenario because the ATF is sticking out their hand saying, give us this forced reset trigger that we say is a machine gun, and they're not offering any immunity from prosecution if you turn it over. So I was very concerned if someone were to hand it over to the ATF that it could later be used in prosecution against them. On the other hand, if you got a letter and then destroyed the item, I was equally concerned that the ATF might accuse you of obstruction of justice and through tampering with evidence, through destroying something that they told you was evidence of a crime after you had reason to know that they were looking into you, that an investigation had been started with respect to you individually. So a couple of concerns there. No easy path out for people. Best path is if a court steps in and does exactly what Judge O'Connor has done and stopped the ATF from enforcing this rule. Now, you may be asking yourself, has the ATF actually prosecuted anybody for possessing a unregistered machine gun simply because they had forced reset triggers, and this was actually critical to the injunction being issued because the ATF, somewhat predictably, argued that there was no threat of imminent harm, and without imminent harm to the plaintiffs, there would be no reason for Judge O'Connor to issue an injunction. And what the ATF argued was, we haven't yet developed a plan to prosecute any of the specific members of the lawsuit or any specific members of National Association for Gun Rights for possessing a forced reset trigger. However, they also did not disavow prosecution. So they also didn't promise that they would not prosecute those folks. They just said, we don't have a current plan to do so. And in fact, Judge O'Connor pointed to several other cases where the ATF has begun prosecuting people for possession of a forced reset trigger in order to reach the conclusion that there is a sufficient threat of imminent harm such that he could issue an injunction. So the fact that the ATF has gone out and started to prosecute people in other places actually resulted in potentially the undoing of this policy that they have right now about forced reset triggers, because the fact that they're prosecuting people shows that there's imminent harm for those that do currently possess a forced reset trigger, and with the imminent threat of prosecution, that's sufficient, along with all of the other elements necessary for the issuance of injunctive relief, which is exactly what's going on right now. Now, the other very interesting thing about this injunction is that the Second Circuit up in New York has gone the other direction, finding that the ATF is likely to prevail on their claim that a forced reset trigger is a machine gun. Both the Second Circuit in New York and Judge O'Connor in the Fifth Circuit heard from expert witnesses about whether a forced reset trigger was a machine gun. The testimony from the expert witnesses was largely identical in both cases, and yet judges reaching the opposite conclusion, setting us up for a circuit split, which of course often sets the path for a situation where the Supreme Court might eventually step in. So, for the meantime, great for members of National Association of Gun Rights because this injunction stops the ATF from prosecuting them for possession of a forced reset trigger, and we're going to keep an eye on these cases and try to keep you informed. Again, if you enjoyed this content, go ahead and hit that subscribe button. Until next time.